Hello aspirants, welcome all of you. Welcome to GS Core. And today we will discuss the approach to law optional, and this is the unique pattern, this questions to concept. So in this session, I'm going to discuss with you the next topic of our discussion, that is amendment of the constitution and evolution of the basic structure doctrine. Why this topic we are taking right now? What is the importance of this? And what exactly what kind of questions you can see in the forthcoming mains examination. So this entire discussion will help you out to think about it. So this question is the previous year question of UPSC law optional. The question was, the procedure adopted for amending the constitution is unique. It is not rigid yet difficult. So basically, such kind of questions are very relevant in this present scenario because the opposition parties are raising the doubts, or they are basically raising a lot of questions against the government, that government is doing this or that, which is actually impacting the Indian constitution. So the main idea behind all this particular discussion which is going on with respect to Indian constitution, and if you analyze this PYQ as well, so you can get one idea that this particular discussion with respect to amendment to the constitution, and more specifically, if we go by the other dimension of this topic, is basic structure. I hope all of you were very well aware that recently on 24th of April, it was the 50th anniversary of the Keshwanand Bharti case, in which basic structure doctrine was laid down by our Supreme Court. And after that, what we have seen, there are a lot of things which have taken place, which clearly says that Parliament cannot do, or what Parliament can do and what Parliament can't do. So everything is subject to judicial review. And if we go by this latest or contemporary change, we can analyze one major thing, that is UPSC is more focused upon the contemporary development. If you analyze the previous year questions of last 5 years more specifically, you can see UPSC is more interested in knowing the latest developments, latest changes. So you have to also change accordingly. You have to change your approach. Because right now, what is happening, all IAS aspirants are just following like the same kind of approach. And this is the biggest issue. They are not focusing upon the contemporary approach. So at GS Core right now, we are making you aware how you can relate the previous year questions with the contemporary development. So if you are being able to relate the contemporary changes, the contemporary points which are happening in the society, you can figure out what kind of questions definitely are going to happen in the forthcoming UPSC examination. So this particular approach will help you out to make better prepared for your exams, because the more you sweat in field, the less you bleed in battle. So by following this approach, questions to concept and this contemporary relation, you will get to know number of things. So please now pay attention to this concept very carefully. So if you come across such kind of questions in the examination regarding this amendment in Indian Constitution, the kind of process or why it is not such rigid like in case of America, or the kind of difficulty, or in case of UK. So basically, when we talk about UK or USA, whereby the amendment process is either highly flexible or highly rigid, but in case of Indian Constitution, what is the scenario? What is the power? So that we have to discuss. So, guys, so now, how exactly you should deal with such kind of questions? If such kind of questions comes in the examination, what should be your approach? So your approach should be, first of all, you should understand what is the concept. So in this particular topic, which is about amendment in Indian Constitution, you should be very well aware about the basic mechanism. So you know that amendment in the Indian Constitution has been given in Article 368. So this Article 368 tells you the mechanism by which you can make amendment in the Indian Constitution. So we have been given three methods like simple majority, then special majority, and then special majority coupled with the ratification by the states. Generally, this simple majority is not considered as an amendment in the Constitution. So this generally happens like when the majority of the members who are present and voting. So this is basically simple majority, but this does not come under the purview of the amendment of the Indian Constitution. When we talk about the amendment with specific reference to the amendment in the Constitution, we obviously talk about the majority, not the simple one, but the, you can say, special one, special majority. And when I say special majority, it simply means majority of the, you can say, 50% of the total membership of the House. So it is absolutely, it is actually about the special majority, which is about minimum 50% of the total strength of the House, the total number of the, you can say, the total membership of that particular House, 50%, plus a kind of, you can say, a majority of minimum two-third members who are present and voting. So two-third members who are present and voting. So it is about the total strength of that particular House, and it is two-third. And if it is with respect to the federal structure, then in that case we do require the ratification by the states as well, like in case of GST. So the main idea is, first of all, whenever you come across this kind of situation, you should explain what are the various kind of majority, simple majority, and special majority coupled with ratification. And after that, you should explain the situation in India, why such particular kind of, you can say, amendment process has been prescribed in such a way. Because we do not have the constitution, or we do not have, you can say, the setup of our country like America or like UK. Those countries came into in existence because of their situational factors. But in case of India, we became this because of our unique specific situational factors. Like in case of America, the initially the 13 states which came together, they came together just to take a revenge with Britain. Okay, and subsequent to that, all those 50 states, they come together for their own interest. But in case of India, we were already a state. We were being, you can say, ruled by the external powers or the forces. And because of those changes, this was like we have seen the partition in our country. Okay, And the kind of, you can say, this uniqueness, this bindingness in our Indian constitution, in Indian scenario, is unique to our country only. So it doesn't make a sense when we used to compare this with the situation of USA or UK. So every country has their own, you can say, background, their own situational factors which lead to this particular kind of like the country status as of now. So for that purpose, we cannot give absolute power to the states, or we cannot give them a choice to separate from India. Okay, or we cannot give such kind of discretion to the states, because we are a country. But in case of America, America was not a country like that. America became a country because of some other factors. You know very well. So you have to understand and you have to focus upon this point in your answer as well, because once you start comparing, it becomes, meaningless. So India is India because India was India actually in the past as well. So it was necessary to keep all those parts of our country all together. So this was the unique thing. So if you try to summarize, or if you try to give this answer in such a way, it gives a better impression in the mindset of the evaluator. Because the biggest issue is every student is writing, every aspirant is writing same kind of answer. So how you differentiate your answer with the answers of others? This is the unique thing which you should learn. So you should write some lines or some words in such a manner which are unique to your answer sheet only. Okay. So once you start, like what is the amendment process given in Article 368, what is the process through these different majorities, and why this is unique to our country, why it is not too rigid or not too flexible, because we follow such kind of federalism in which it is necessary to keep this cohesiveness, to keep this bindingness in such a way. It is necessary for our country to survive as a country. Okay. After this, if we go by, so you must have got this answer now. So you should plan your answer in such a way. If it is a 10 marker question, then start explaining like Article 368. So first start your answer with Article 368 only. Start, mention various type of the simple majority or special majority. Okay, so all things which I have just mentioned you. If possible, try to give an example as well. Okay. And mention the reason why India has this unique kind of amendment process, because the historical factors of India are altogether different from the historical factors of America or Britain. So this comparative study with such countries doesn't make sense. And then try to conclude. Try to conclude in 2 or 3 lines. So that should be your approach. If it is a 15 marker question, then you can elaborate a little bit more as well. But if the question is only about like amendment process or the uniqueness, it will be obviously within 10 marker question or at the max 15 marker question. If it is a 25 marker question, then obviously the pattern of the question will change, and it will obviously include different dimension of this particular chapter as well. And what is this different dimension? Please have a look on this by looking at this probable question. And believe me guys, this question you might see in this exam right now. Parliament's power to amend the constitution is a limited power, and it cannot be enlarged into absolute power. Please read this question very carefully. This question has been designed with so many factors to keep in mind, and you have to write your answer in such a way only. In the light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the constitution by expanding its amending powers or not? So this kind of question is more relevant if we see that this year is the 50th anniversary of Keshwanand Bharati case, and right now there is an ongoing tussle between the government and the judiciary, and even a lot of allegations are being put by the opposition against the government that they are destroying the fabric of this Indian constitution. Whether these are correct or not, we will not go into this right now. The main point is whether such particular kind of like basic structure or the kind of the situation which we are witnessing right now, in such in this dimension, you should write down your answer. So how to write down this particular answer, I will discuss with you as well right now. So in this particular question, what you should do, see guys, how you should write down this kind of answer. So first of all, you should start, like how this basic structure came into in existence. So you have to start writing the journey of basic structure. The journey of basic structure. So the journey of basic structure starts from, first of all, the first constitutional amendment in 1951. And at that time, because after this independence and partition, in India, it was required that we should go with this, you can say, agrarian reforms or nationalization kind of schemes. So to keep such socialist kind of mindset, government started doing some reforms. So due to some reforms, and more specifically abolition of zamindari system, and to keep this nationalization concept, so that the land distribution should be rationalized, government come out with this first constitutional amendment, in which it was basically pertaining to agrarian reforms. And Article 31A and 31B were inserted by the amendment. Now the point was, these were basically, at that particular time, even the Supreme Court, even that at that time the government was provisional government. Please keep this in mind. Provisional parliament, you should say. So the government, the Constituent Assembly was working as a provisional parliament. So at that time, government was having this agenda, and ultimately, like judiciary was also of the view like government whatever is doing is correct. Okay, so at that particular moment of time, before Golaknath case, everything was like going in line with the government, and the judiciary was like in line with the government. Hardly there was many differences. So more or less, you can say the differences were not as such sharp, or there was not so huge kind of the differences between the government and the judiciary, because they were at the very they were in line with each other. The only dispute was about like compensation scheme, like compensation. That a compensation when the land is being acquired, compensation should be adequate. So this was actually going on, and even the government inserted Schedule 9 as well to keep some laws on outside the review of this judicial review. So in the first case at that time was Shankari Prasad versus Union of India, whereby Supreme Court upheld that these Article 13. Article 13 is concerned only with the ordinary laws. Article 13 is only concerned with the ordinary laws, and constitutional amendment does not fall under the ambit of Article 13. So any kind of constitutional amendment is outside the ambit of judicial review, and Parliament has the power to take away even the fundamental rights as well, because the starting point was about the right to property, the fundamental right to property actually. Same kind of the proposition was upheld by the court in, you can say, Sajjan Singh case as well. Same kind of view was upheld by the Supreme Court at that particular moment of time in 1965. But the actual tussle started in Golaknath case, whereby in 1967 in Golaknath versus State of Punjab, Supreme Court held that Parliament doesn't have the power to take away or to abridge the fundamental rights. So this was the starting point whereby this tussle started actually. So Supreme Court held that Parliament doesn't have the power to take away the fundamental rights because they are under the ambit of Article 13 and even they are under the ambit of judicial review, any kind of amendment. So to overcome this particular issue, government came out with 24th Constitutional Amendment Act. Government came out with 24th Constitutional Amendment Act in 1971. And to tackle this particular controversy between this Golaknath case and this 1971 amendment, Supreme Court, there was another case. This is the one of the famous case, all of you know, Keshwanand Bharti case. So now you have to just start writing about Keshwanand Bharti case, and which was of 1973 judgment, 24th of April. And after Keshwanand Bharti, in Keshwanand Bharti, this basic structure doctrine was propounded by the court. And after this Keshwanand Bharti, to tackle this case, government made certain changes as well. And even the 42nd Amendment in 1976, which was the biggest, you can say, a game changer in this Indian constitutional journey. But after that, this was even held in Minerva Mill case in 1980, that all such kind of amendments during this emergency and 42nd Amendment, because many of them were overruled through this 44th Amendment Act. But in Minerva Mill case, Supreme Court once again upheld that basic structure doctrine has the power to judicial review. So this is, you can say, this Keshwanand Bharti and Minerva Mill case, they are of utmost importance for all of you. So you should mention these two cases very clearly. And after that, even Minerva Mill case, you can also mention this Vaman Rao case of 1981. In Vaman Rao case, Supreme Court held that this basic structure doctrine is applicable after 24th of April 1973 amendments only. So before that, whatever has happened, it is okay. So whatever has happened after this basic structure doctrine is subject to judicial review. So it was given judicial review, supremacy was given to it. And Iyer Colo case as well. So this is the journey of this entire basic structure doctrine. Now, if after mentioning all this kind of structure in your answer, main thing is conclusion. What should be your conclusion? This is the main point. So in case of conclusion, I should say you have to try to give the balanced answer, because Parliament is saying that this judicial review, even sometime this has been criticized that this basic structure, when it was propounded in this Keshwanand Bharti case, was not defined properly. It was held, but it was not defined. So by the passage of time in the various cases, Supreme Court defined this basic structure in various angles. So the point is, this particular Keshwanand Bharti case, basic structure doctrine case, and so various judicial pronouncements, somehow this has become a case of judicial absolutism. Now the point is whether this judicial absolutism is also good for this country or not. So whether judiciary has become a superpower even above the parliament or above the executive or not, this is a point which you should discuss or which you should think about, and you should write down your answer in such a way only. And this is only up to you how you should write down this answer. I am just leaving it to you. Just think about it and try to give a balanced answer. As a teacher, I should advise you, do not write your answer in one direction only. Try to write down the conclusion in a balanced manner, that this should be defined, this should be properly, you can say, summarized. But judiciary, all the time when it is encroaching upon the powers of legislature or the parliament, this also creates a trouble for the democracy as well. So you should have this separation of powers, and you should not interfere into the domain of others as well. So this is all about from my side. Rest you can decide what should be your answer in such a way. That's all. Thank you all of you. Thank you very much.